Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and a quality of life that she's accustomed to. That is still need.
Witnesses, what motions were those for?
We disclosed we had an income analysis done of Mr. Yost, Your Honor. That was disclosed on January 17th through Jeff Querin. So the only part of the motion that we have dealt with that obviously is the motion to modify spousal maintenance. If the court would recall, initially when we filed this case, we're the petitioner, we had set spousal maintenance at $9,000 a month. And the court actually called me, this would have been through the ex parte temporary order, inquiring as to when the last year of tax returns we would have had available at that time, and that was 2018, which Mr. Yost at that time had made significantly less than what he had made over the last 3 years that we've averaged. So at the time, maintenance has been set based off of an income of Mr. Yost around $338,000, $318,000 or somewhat. And the report we've had from this income analysis that Jeff Quern has done 7 weeks ago has his income average over the last 3 years at $664,000. So
this is a turning point in the case. The petitioner's attorney reveals that Mr. Yost's income has nearly doubled, now averaging about $664,000 a year compared to $318,000 in past tax returns. That's not small change. It's a financial game changer. Spousal support usually weighs both need and ability to pay, and numbers like these put real pressure on the court to reconsider the original order. But here's the real debate. Should support rise simply because one spouse earns more, or should it stay tied only to proven reasonable expenses?
That's not brand new news. Again, that report was issued and sent to Mr. Thompson within a couple of days, if not on January 17th. So, there's been ample time to respond to that. Frankly, if we're disclosing expert reports by statute, Mr. Thompson would have had to have a responsive expert opinion within 30 days of receiving notice of us issuing that report. So that's not been done. We're outside the 30-day window. So I really don't know what the dispute is on this motion with respect to the spousal maintenance, besides trying to continue to delay this matter. So again, we're ready to proceed. It's all argument. There's not any need besides the domestic relations affidavit, which is a sworn statement. There shouldn't be any need to question anybody on the witness stand. This can be done through argument.
Your Honor, and I disagree completely. If we review Ms. Yost's domestic relations affidavit, every single expense that she listed, she deems as estimated. Every expense without a single exception.
Now the defense reveals its strategy, challenge the credibility of the expenses. Every cost the petitioner listed, rent, food, even attorney fees, is labeled as an estimate. The defense argues that without receipts or records, the court has nothing solid to rely on. It's a smart move, because while income can be proven with pay stubs and tax returns, lifestyle needs are far less concrete. What do you think? Should courts accept estimates, or should every claim require hard proof?
Deems as estimated. Every expense without a single exception. As the expert report, if I have a reply to their expert report pursuant to the rules of civil procedure, that's 30 days. I can have an independent expert, separate and apart, Your Honor. I have a demonstrative exhibit, which I anticipate. Let me try to be as succinct as I can. We cannot get this done in 45 minutes. Any one of these motions, Your Honor. Any one. The domestic relations affidavit is riddled with, they're all estimates. I'm entitled to inquire of Ms. Yost as to what her actual expenses are, because she has not provided a single solitary actual expense to justify any deviation from the court's order of spousal support.
None, Your Honor. Every figure presented is merely an estimate, and the court cannot rule on a request to modify spousal support based solely on guesses from the petitioner.
There's no case law to discuss that, Your Honor. Estimates are commonly used because the DRA has to be filed prior to the time of trial. Usually most pretrial conference orders require 10 days in advance of trial or 30 days, depending on the court and jurisdiction you're in. At that point in time, it is very common practice to have the exact amounts put in. Otherwise, you put estimates in. That is something I've commonly done in 15 plus years of domestic practice. And frankly, if we're talking about my client's expenses and we want to get into the analysis on spousal maintenance, it really doesn't matter, because need doesn't have to show, of course, we're talking about need versus ability to pay. Clearly, there's an ability to pay. But when we start talking about need, it doesn't matter if my client.
Listen closely to this argument. The petitioner's attorney insists that spousal support isn't just about survival. It's about maintaining the lifestyle enjoyed during the marriage. That's a strong point, because support is meant to reflect fairness, not just cover basics. If a couple lived in luxury together, should divorce mean a sudden downgrade? The law often says no. But where's the line between reasonable lifestyle support and pure entitlement? That question sits at the heart of many spousal maintenance battles, and today's case puts it squarely in focus.
Or has to live or needs the exact amount of money she's requesting by spousal maintenance. It is need as a standard of living. Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and a quality of life that she's accustomed to. That is still need. And that's what we're dealing with here. Again, there's been ample time for Mr. Thompson to respond to Dr. Querin's report from January 17th that we provided to him. We are ready to proceed. This has been set on the court's calendar for a number of weeks. We need to get moving on this immediately. There's no reason to have a half day or a day long hearing over motions to modify a temporary order. It's not that complicated.
I'm sorry. And Your Honor, I'm astounded Mr. Olson made the argument that need is not a factor. Need is most certainly a determinative factor as to spousal support. And the court cannot make a decision when every, not just one or two, every expense is estimated. And it is not for the time of trial. She is asking for a change right now. So the need right now is what we need to determine, not what she may think she needs in a year or two, which I don't even know where she's coming up with these numbers, Your Honor. Most certainly $4,000 a month in attorney's fees.
Defense just dropped a bombshell. $4,000 a month in attorney fees, nearly $50,000 a year on lawyers alone. They argue this proves the petitioner's numbers are exaggerated. If she's spending that much on legal help each month, what does it say about her financial planning? Is this a genuine divorce expense or a tactic to push Mr. Yost for more support? Now, the judge must decide, are these costs a true need or a calculated strategy?
Every month. But, Your Honor, we're putting the cart before the horse. I didn't say a day. I think it can be done in half a day. The court does not have the ability. I don't think the court has the ability to make an informed decision based upon argument when there are all of these issues and all of these issues with the documents that have been submitted. We have over 300 pages of exhibits, Your Honor, for a status conference. That is not status conference material, Your Honor. That's a half day in person, as this court's procedure has been throughout this case and the other cases I've been involved with, Your Honor.
All right, if you all can give me just, I'm going to take a short recess to review these docket notes. Give me just a second.
There it is. The judge calls a recess. Why? Because the paperwork is staggering. Over 300 pages of exhibits for what was meant to be a simple status conference. A quick check-in has ballooned into a mountain of reports, affidavits, and motions. It's a classic family court truth. When money and pride collide, cases can drown in documents and delays. Judges hate it for clogging the system. But for some attorneys, dragging things out can be a strategy. What do you think? Is this level of paperwork justified or just legal theater?
All right, we'll go back on the record. Same appearances as before. All right, going back through the docket notes. January 14th was the last time we were here. The parties were still exchanging exhibits. I don't think at that time any of these new motions had been filed yet. I think those were, is January 29th, the date that those were filed. So we set it for February the 10th for a status by Zoom at 3 o'clock. We got the notice about your mom, Mr. Thompson. Sorry to hear about your mother. It was continued for very good reason. Again, for status. So typically when motions are filed in between, when we've already got a status hearing filed, I take that as an opportunity to determine, have any of these motions been resolved? Do we still need more time to get documents? I typically don't utilize that as a time to hear those motions unless it's something minor that we can get addressed. So in my mind, I tend to believe with Mr. Thompson here that this just needs to be set so we can hash everything out. Frankly, a lot of reading through these motions, I thought a lot of this stuff would have been resolved already. I mean, these are the types of issues that aren't ones that we typically have to spend so much time trying to resolve, just the exchanging information, making some concessions to help one party get along during the pendency of the case. This case is getting long in the tooth. Where are we at on domestic conciliation?
Judge's frustration is obvious. These are matters that should have been settled in negotiations, not stretched into endless hearings. He even notes the case is long in the tooth, dragging on far too long. Every delay, every motion, every conference drains more time, energy, and money. For the judge, it's about keeping the docket moving. For the parties, delays can become a weapon, each side hoping to wear the other down. In divorce court, justice often takes a backseat to sheer endurance.
Parties are in with Richard Samanago. They've got another follow-up appointment. I think they've met with him twice. Got another one in another week. They're still in the mediation phase of it. It's clearly going to go to an investigation aspect for DC. So I can follow up with Richard this week. We had kind of planned to do that anyway, but I would anticipate probably at least another 3 or 4 weeks before we have anything as far as feedback from him.
All right. I understand, Mr. Olson, you're wanting to get this stuff resolved. I want to get cases resolved probably more than you guys do. But this is a status, and this is what we're doing. We figure out, has anything been resolved? What do we need to do? Well, it doesn't sound like anything's been resolved, that we just need to set everything for hearing. And but I want to set an afternoon, and it'll be an in-person hearing. And we'll take up everything that we can that has not been resolved at this hearing.
Your Honor, may we try to set something within 2 to 3 weeks, and literally whatever I need to do to make a time work, I will make that happen. And I've actually got some good availability in the next 3 weeks for things. I mean, it's just something needs to get moving on this for my client's benefit. So I would greatly request that we be able to have something set at least within 2 to 3 weeks.
Well, I know I've got spring break coming up, not next week, but the week after that. I think I've got a criminal docket week, so I don't know if I can do it that soon, Mr. Olson. Angela, when do we have a half day?
Not until April 30th at 1:15.
April 30th at 1:15.
That works for me.
It stands. The judge has set a firm in-person hearing for April 30th. Both sides will finally lay out their evidence and let the court decide what spousal maintenance should be. One spouse is asking for up to $9,000 a month to maintain her lifestyle, while the defense attacks inflated estimates and questionable expenses. The ruling could set a key precedent on lifestyle support versus actual financial need. If you were the judge, would you grant the full $9,000 or push for less? Share your thoughts in the comments, hit like, and subscribe so you don't miss the next twist when this case returns.